primer on mechanics liens in California. Today, we're going to cover what a mechanics lien is, the pre-lien requirements, preparing and recording the lien, enforcing the lien, and defending the claim. So what is a mechanics lien? It's a hold against real property that is filed by an unpaid contractor, subcontractor, laborer, or material supplier that is recorded with the county recorder where the property sits. And if it remains unpaid, that contractor or supplier can then pursue a foreclosure action, which can result in the sale of the property in lieu of compensation. The right to a mechanics lien is actually derived from the original California Constitution enacted back in 1879. And the goal was to give laborers and material men security for their claims. It is the only creditor remedy protected by the Constitution. It is a remedial statute, and courts have liberally construed them to protect laborers and material suppliers. So who can record a lien? Licensed contractors, subcontractors, subcontractors, design professionals, and material suppliers. Unlicensed contractors and material suppliers to a material supplier, in other words, a secondary material supplier, cannot record mechanics liens. The general requirements, just an overarching comment, there are several statutes. It's a significant framework that covers mechanics liens in California. They typically must be followed to the letter. There's usually little leeway in failing to follow the various requirements. So adherence to them and reviewing them carefully is critical. So the first step is the preliminary notice, previously called the 20-day notice. And this is prepared within 20 days of commencing work on the property, and it's done by contractors and suppliers, and it is served on owners, direct contractors, and lenders if there is one. And it provides notice about the work that the individual or corporation is performing on the property. This is a necessary prerequisite to recording a mechanics lien. Failure to issue a preliminary notice can be fatal to the mechanics lien later. The code outlines very strict requirements for what's in the preliminary notice, including the name and address of the construction lender if there is one, the owner's name and address, the direct contractor's name and address, the party that this particular claimant has contracted with, a general statement of the work provided, such as electrical work or framing, that type of thing. And then a description of the property, such as the typical street address, would be sufficient. And there's a specific 235-word statement. It's provided in the statute, and it must be included in the preliminary notice. It must be in boldface type, and it's within the civil code section. So you're best just to copy and paste it and make sure it reads exactly as required. So there's an exception. Direct contractors do not have to serve a preliminary notice on the owner. They do, however, need to serve one on the project lender if there is one. And in the context of these statutes, a direct contractor is one that is in a contract relationship with the property owner. So that would not therefore be a subcontractor or a general contractor that is doing work for a lessee. While it's not statutorily required, it's not bad business practice to serve one on the owner, even if you are not statutorily required. So late notices. You can serve your preliminary notice outside the 20-day window. It's best not to. However, if you've realized you're at 21 days, go ahead and issue that. The lien rights will only cover the work performed in the 20 days preceding and thereafter, but it's best to get that out the door regardless of when you realize you've missed that 20-day window. The code also specifies specific manners of delivery, including overnight mail, express, and registered mail. And the preliminary notice must be accompanied by a declaration about the manner and timing of delivery. It's often referred to in the legal world as a proof of service, and it just indicates that you've complied with the requirements for serving the preliminary notice. So lien requirements. Liens can attach to both residential and commercial property, and a contractor is permitted to record a lien even if the property owner did not request or contract for the work. So this is common in the commercial context where a tenant or lessee hires the contractor to perform tenant improvements. There is a separate framework for notices and mechanics liens functions in public works projects. That's a whole different set of requirements and statutes. I won't be covering those today, but be sure to check those out if you are working on a public work. So in the commercial context, a owner can protect themselves by posting a notice of non-responsibility. And this occurs when the property owner is not the party that is contracted for or requested the work. And this is essentially trying to stave off a potential mechanics lien. The notice must strictly comply with sections 844, 8100, and through 8118. So there's some specific requirements of what's included in that notice, and it must be posted at the job site and recorded within 10 days of the landlord's knowledge of the construction activity. The notice does not protect in all instances, and it does not protect at all where the owner has ordered or caused the work to be performed. In that situation, it is deemed invalid. Also important for a commercial property owner to note that the termination of the lease does not defeat the claimant's lien claim. In other words, if the lease terminates on a certain date, the lien itself does not expire at that same time. They're not necessarily dependent on the other. A question comes up often is how much of the commercial property is liened against? And this is a factual question. In certain circumstances, it can be limited to the tenant's leasehold interest, that specific part of the property that they have a right to. And in other circumstances, it can exceed that limited interest. It turns on a number of different factors, including how much the owner was involved and consented and actually aware of the work that was being done. Okay, moving on, preparing and recording the lien. The most important thing to note is that there are strict deadlines for recording a lien, which is done by filing it with the county recorder where the property sits. And the deadline varies depending on whether the claimant is a direct contractor or a subcontractor or supplier. So for direct contractors, the lien must be recorded within the earlier of two events: 60 days after a notice of completion is recorded, or if no notice of completion is recorded, then direct contractors have 90 days after completing the improvement. And a notice of completion is a document that's recorded against the property with the county recorder, and it indicates that a certain work of improvement has been completed. That notice of completion can also be important in the construction context, as it can trigger the statute of repose for defect claims. Subcontractors and suppliers have a different deadline, and they must file within the earlier of two events after they've completed their work, and that's 30 days after a notice of completion is recorded, or 90 days after the completion of the work where a notice of completion has not been recorded. So lien requirements. Civil Code Section 8416 sets forth specific language that must be included in the lien, including the statement of the demand, the claimant's address, meaning the contractor or supplier, the property owner's name, who they provided the services to. Sometimes that's not always the property owner. The services that were provided, a description of the job site, including the legal address, and then a proof of service attesting to the delivery of the lien. And like the preliminary notice, there is a specific statement that must be printed in at least 10-point boldface type, and the last letters of the last sentence shall be printed in uppercase, excepting the address, which is in lowercase. And it looks like we've got on this slide, and it's included within the statute, and it's best to just copy and paste it and make sure it mirrors exactly what they've required. So service of the lien, like the preliminary notice, there are specific requirements for the manner of delivering the mechanics lien. So in addition to recording it with the county, you must serve it on the owner and on the contractors, and it's through registered mail, certified mail, and again, you must have a declaration stating the manner and the timing of the service. And the code is specific that if you have failed to serve the mechanics lien as required by the code and fail to include that specific language on the slide just before this one, it renders the claim of the mechanics lien unenforceable as a matter of law. So it is critical that you strictly adhere to what code mandates for what is included in the lien and what is and how you serve that lien. So the next thing in the mechanics lien life is filing the complaint, and that would be done with the court where the property sits. The cause of action is commonly titled foreclosure on mechanics liens. A few things to know: if the owner is in bankruptcy, you must get permission from the bankruptcy court to file the foreclosure action. So keep this in mind, as that you may have to think about that a little earlier than the filing deadline, as that may require some time to get the paperwork back from the bankruptcy court. And a second thing to keep in mind is that even if the contract requires arbitration, you should still file the complaint with the Superior Court. You should preserve your rights to arbitration. And likewise, a property owner that is defending an action that is should also indicate that they are preserving their rights to arbitration, but you must still file the case with the Superior Court. Okay, the deadline. This is very critical as well. It is a strict 90-day deadline to file the complaint with the court, no later than 90 days after recording the lien. And alternatively, you can do that as soon as possible, but you must file your action within 90 days. There's only one true exception where the owner has agreed to extend the deadline, and that's commonly termed as an extension of credit. These are not very common in practice, and it must be a very explicit agreement. And even in the case of an extension of credit, the action must still be commenced within a year of completing the work of improvement. Another requirement is a filing of a notice of pendency of action, also known as a lis pendens. So lien claimants must record a notice of pendency of action with the county recorder within 20 days after filing the foreclosure action. And this puts potential purchasers or encumbrancers on notice of the lien claim against the property. If you fail to record this notice of pendency, subsequent purchasers and encumbrances without actual knowledge of the foreclosure action can take the property free and clear of the lien. So for property owners, if they are of the impression that the lien is invalid for any number of reasons, either substantively defective or there's procedural issues, an owner can petition the court for an order to release the property lien, and that is brought under Civil Code Section 8480. And it can be done before the foreclosure action is filed. So this can be done even before there is a lawsuit pending in the Superior Court. So this might come up where there has been a lien on your property for more than 90 days, no foreclosure action has been filed. It is now an invalid lien, and the owner can petition the court to rule on this narrow issue. There is a meet and confer requirement in the code. So the property owner must send a written demand to the lien claimant demanding they release the lien at least 10 days prior to filing the petition. And note that the prevailing party on this petition is entitled to recover their attorney's fees. Similar to a petition is a Lambert motion, and it's actually, this is different in that it is brought after a complaint is filed. The purpose was to provide property owners with a speedier recourse to protect their property rights against an invalid lien. And the question before the court is still the same, as whether there is substantial validity of the lien against the property. Also, it would be wise if you've got a notice of pendency action in the same lawsuit, you can file your motion to expunge that at the same time. So defenses, if neither the petition or the Lambert motion get rid of the lien, or that doesn't dispose of all of the claims in the lawsuit, for example, there's other causes of action against you, the next step might be filing an answer with the Superior Court, assuming you don't have any legal challenges to the complaint. And there's a number of affirmative defenses that a property owner might be able to assert, such as a defective lien, failure to send a preliminary notice, some substantive issue with the lien, statutes of limitations, or the contractor not being licensed is another defense to a mechanics lien. Another option for the property owner is that they can bond off the lien, and this is a mechanics lien release bond that can be obtained from a surety company. They typically, you have to bond 125% of the value of the lien, and the premium that you pay to the surety company varies between 1% and 5%. So effectively, this bond will clear the lien from the deed, and then the bond becomes the alternate security for the lien liability. So I've provided a lot of information today, and there's substantial more information within the statutes and case law. So, but in closing, I wanted to just remind you of some critical deadlines that are imperative to follow to perfecting your lien rights. And that's the 20-day preliminary notice, and that's done within the first 20 days of providing work on the project. And then thereafter, you've got, depending on whether there's a notice of completion, you've got 30, 60, or 90 days to record your mechanics lien. And then 90 days is the deadline to file a complaint to enforce the mechanics lien. And that is a strict statutory deadline that should be followed. Well, thanks for tuning in, everyone. If you've got any questions or want any further information about mechanics liens, please reach out to us. We're happy to assist you in any regard. Thanks, and take care, everybody.